Is the interpreter on the line? Hello? Do I have an interpreter on the line?
Yes.
All right, good morning. It is 9:10, March 3rd, 2021. If I could have the counsel for the parties, please put your appearance on the record, and then we'll get started.
Taylor May on behalf of
Je dis, c'est les 9h10, 3 mars 2021. Si avocat est capable de venir sur le corps.
Taylor May on behalf of the Office of the State Attorney.
And Kathy Kennedy Swanson on behalf of the Office of State Attorney.
Letitia George on behalf of the Office of the Public Defender.
Letitia George capable être sous l'office défenseur public là.
Has the interpreter been sworn this morning?
Non.
Please raise your right hand to be sworn.
Do you swear to translate from Creole to English, English to Creole, truthfully in these matters here today?
I do.
Ma'am, please tell me your name.
Nadia?
My name is Anne.
I'm sorry, I was talking to the defendant.
OK. Madame, s'il vous plaît, ben moi non.
Nadia?
Nadia.
Yeah.
What's your last name?
Edmund.
All right, you're here in case number 21 CF 2553AO, charged with aggravated child abuse.
Donc, ou là, dans le cas 21CF253AO, il est chargé de abus timoun aggravé.
I'm going to appoint the public defender's office to represent you.
Donc, je peux appointer au monde dans l'office public défendeur pour représenter.
There is probable cause in this case.
Il y a un cas probable dans le cas ça.
Does the state wish to be heard as to bond?
Est-ce que state a besoin de parler à propos de bon?
Just that the state would ask that the court just set a reasonable bond. She doesn't have any history, but she does not qualify for PTR. So
No.
just a reasonable bond, Your Honor.
Donc, il n'y a pas aucune histoire bagay que le fait. Donc, il n'est pas qualifié pour TR. Donc, pas un bon.
Ma'am, your bond is $5,000. At this time, you're not allowed to have any contact with your son.
Donc, Madame Bon, c'est $5,000. Pour qu'on y a, ou pas doit avoir aucun contact avec petit garçon là.
Does the state have any thoughts on bond conditions?
Est-ce que c'est là qu'il y a aucun bagay que vous voulez dire sous condition bon?
Yes, Your Honor, no contact, but to follow DCF's plan.
All right, ma'am.
Oui, juge, pas de contact et puis suivre directive DCF.
I will order that you're not allowed to have any contact with your son, and I will also order that you have to comply with all recommendations and plans set by the Department of Children and Family Services.
OK, donc ou pas supposé qu'il y ait aucun moi ordonné pour pas qu'il y ait aucun contact avec petit garçon et puis ou supposé suivre toute directive département Children and Family.
You're not allowed to possess a weapon of any kind, firearm, or ammunition.
Ou pas supposé qu'il y ait aucune qualité d'arme, arme à feu ou bien munitions.
Good luck, ma'am.
Bonne chance, madame.
Thank you, Madam Interpreter. I believe that's the only Haitian Creole that I have this morning.
Thank you for using our service.
Okay, but now, how do we get the next interpreter? Is this Spanish?
Yes.
Okay, so I can just call this.
Good morning, Your Honor. This is Alan Figueroa, State Certified Spanish Community Interpreter.
Good morning. Has the interpreter been sworn?
Yes, Your Honor.
All right, he has the headset on. Can you connect to the headset and ask if he can understand you?
He can hear me, Your Honor.
Okay. Please tell me your name.
Juan Pedro del Orso García. Juan Pedro del Orso García.
Juan Pedro del Orso Garcia.
Sir, you're here in case number 21 CF 2552AO, charged with tampering with a witness to hinder communication to law enforcement and battery domestic violence. I'm going to appoint the Public Defender's Office to represent you. There is probable cause in this case. We have a witness. Ma'am, do you wish to testify today?
He also needs an interpreter, Your Honor.
Can the interpreter
Señora,
get
¿usted desea testificar hoy?
over the loudspeaker? I believe the witness needs your services as well.
Yes, Your Honor. Yes. Señora,
Ma'am,
¿me
do you
escucha?
wish to testify today?
Yes.
Who's this?
Ma'am, what is your name?
Hold on.
¿Su nombre, señora?
Yasha Celestine.
All right, please raise your right hand to be sworn.
Levanta la mano derecha, por favor.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
¿Jura decir la verdad, solo la verdad y nada más que la verdad?
Sí.
Yes.
State, you may proceed.
Bien, adelante, Fiscalía.
Ma'am, what is your name?
¿Cuál es su nombre, señora?
Yasha Celestine.
Yasha Celesti.
And what is your relationship to Mr. Delos Garcia?
¿Y cuál es su parentesco en relación con el señor García?
Wife.
And are you afraid of the defendant?
¿Siente usted temor del acusado?
Ahora mismo en estado de embriaguez, sí.
Right now, when he's drunk, yes.
Are you afraid of him when he is not drunk?
¿Siente usted temor de él cuando él no está en estado de embriaguez?
No.
No.
Would you be afraid if he were to be released from custody?
¿Sentiría usted algún temor si él quedase en libertad de la cárcel?
No.
No.
And in this altercation, were drugs or alcohol used?
¿Y en este incidente hubo algún tipo de uso de alcohol o de drogas?
Sí, alcohol.
Yes. Alcohol.
And has any incident like this ever happened before?
¿Ha ocurrido algún incidente como este en el pasado?
Sí.
Yes.
Do you know when the last time was?
¿Sabe cuándo fue el último?
A few weeks.
And are you willing to call 911 if anything were to ever occur in the future?
¿Llamaría usted al 911 si algo en el futuro vuelva a ocurrir?
Yes.
That's all I have, Your Honor.
Does the defense
Eso es
wish?
todo, señoría.
Oh, sorry. Does the defense wish to inquire?
No, Your Honor.
¿La defensa tiene alguna pregunta? No, su señoría.
Sir, at this time, your bond is going to be $1,000 on count one, $100 on count two. I'm also placing you on pretrial release with special conditions that you're not allowed to have any contact with the victim. Do you understand what no contact means?
Bien, señor, en este momento emitiré la fianza en $1,000 ante el primer cargo y en $100 ante el segundo cargo. Se le concederá la libertad provisional, pero prohibiéndole el contacto con la víctima. ¿Sabe lo que significa prohibición de contacto, señor? Yes.
I'll order that you maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. You're not allowed to possess or consume any alcoholic beverages. You'll be subject to random alcohol screens. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you understand?
Bien, señor, le ordenaré que debe buscarse otro paradero. Se le permitirá regresar a la residencia una sola vez junto a las autoridades para recoger sus pertenencias. Se le prohíbe el consumo de ningún tipo de bebida alcohólica y deberá someterse a análisis de alcohol al azar. Se le prohíbe la tenencia de ningún tipo de arma o de municiones. ¿Se entiende todo eso, señor? Yes.
All right, good luck, sir. Thank you, ma'am, for coming.
Gracias, buena suerte. Gracias, señora.
I believe that's the only case I have for the Spanish interpreter. Thank you for your service this morning.
Not a problem, Your Honor.
Please tell me your name.
Wilton Calder's.
Sir, you're here in case number 21 CF 2551AO, charged with robbery by sudden snatching, tampering with a witness to hinder communication to law enforcement, battery, domestic violence, aggravated assault with a deadly weapon, domestic violence, petty theft, and possession of cocaine. I'm going to appoint the Public Defender's Office to represent you. Ms. George, did you wish to be heard?
Yes, Your Honor. On the aggravated with a deadly weapon, we're arguing that there is no PC. In the arrest affidavit, it states that my client allegedly picked up a gas can and put it in the car, but other than that, there was no weapon used in this case, and a gas can by itself cannot be used to kill someone.
Does the state have any response?
Your Honor, in regards to the gas can, it could be used as a weapon to swing and hit the victim. So the gas can arguably could be a deadly weapon.
Your Honor, and we would argue that case law makes clear that in order to have be charged with aggravated assault with a deadly weapon, it has to be used in its normal intent. The way that the weapon is used has to be able to kill someone. So just because I have a gas can doesn't make that a deadly weapon, because I can swing. Even if you swung and hit someone with the gas can, doesn't mean that they would, when used in its natural intent, could kill someone.
All right, Counselor, how about if you use the gas can to burn the house down?
Yes, Your Honor. However, it merely says he did threaten in the arrest affidavit to burn the house down. However, he took the gas can, put it in his car, and drove off.
That's why it says something. Say that burning a house down and getting a gas can is the deadly weapon, but, yeah, whatever.
Make sure there's nothing else. They threatened to burn the house down.
So according to the probable cause affidavit, it says, he said he was going to, quote, burn the house down, exited the vehicle, picked up a gasoline can with gas in it, then re-entered the vehicle.
And drove off. Correct.
He drove off after she called 911.
Right, Your Honor.
So I would agree with you, there's no aggravated battery with a gas can, but isn't assault the threat,
With a deadly weapon, Your Honor.
right?
Case law makes clear that in order to have a deadly weapon, it could be a gun, a knife. Those type of things can kill someone, but a gas can alone, in its intended use, cannot kill anyone.
But it can to light something on fire and kill them, which is what he claimed he was intending to do, which that would be the assault. So if he said, I'm going to hit you with this gas can, maybe you could argue that that's not what the gas can is intended for, but I don't know. But I think the nexus is, he said, I'm going to burn the house down, and grabbed a gas can with gas in it. It appears from the probable cause affidavit, he only left with the gasoline can because she called 911, so he was afraid of being arrested. But isn't having the gas can with gas in it, saying I'm going to burn the house down, that's an assault. The battery would be if he touched her, or if he then poured gasoline in the house
Right.
and lit it on fire. But the assault is the threat of an imminent battery, right?
With a deadly weapon. My argument is there is no deadly weapon. That's my argument, Your Honor.
Is fire not deadly?
I'm not saying an assault there is no assault. I'm saying there is no deadly weapon.
But, so fire is not deadly?
The gas can alone, unless you light it on fire, at that point it becomes deadly. But gas alone, a gas can with gasoline alone, is not a deadly weapon.
What says the state?
Your Honor, I'm looking at the jury instruction for aggravated assault. For a deadly weapon is any object that will likely cause death or great bodily injury or harm if used or threatened to be used in an ordinary and usual manner contemplated by its design and construction. I think with the defendant's statement of he was going to burn the house down, grabbing a gas can with gasoline in it, and so a gas can with gasoline in it, intent is either to start a fire or to drive a car or something like that, but to cause combustion. Therefore, it is being used in a deadly weapon manner. It's an assault. It's the threat. It is not the actual contact with the victim.
Counselor, I appreciate your argument, but I think I agree with the state. I think there is probable cause for that arrest.
Favorite because they're time.
Do you wish to be heard as to bond?
Me, Your Honor? No, Your Honor.
Okay. Does the state?
No, Your Honor, just to take into account his prior batteries, given that this is a DV case.
All right, at this time, sir, your bond on count 1 is going to be $10,000, count 2, 150, count 3, 100, count 4, 150, count 5, 100, count 6, 150. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You're not allowed to possess a weapon of any kind, firearm, or ammunition.
Yes, ma'am.
You're not allowed to return to this scene for any reason at all. Do you understand?
Yes, ma'am.
Do you have any belongings there?
I have, look, I've been living there with her for 4 years.
So do you need to return one time with law enforcement officers?
I'm gonna have to get my stuff out of there.
All right, so I'll say that you have to maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that through her. You understand
I
that?
got you. Yes, ma'am.
Because he threatened to burn the house with the gas can. Yeah, we used it, right? Unlike the other case.
Can I say something, Your Honor?
You can.
With the first guy, I never made the statement of burning down the house, too. She was like 20 yards
Don't
away
talk
from-
about the facts of the case, please.
So
I never made that statement.
that's something you'll want to talk to your attorney about, and then they can file a motion in front of the trial judge. At this time, I'm not saying that everything here is true. I'm saying there's probable cause to believe that it happened. But that doesn't mean this is beyond all reasonable doubt. We're not having a trial today. So your attorney can file any motions they think are necessary.
Yeah.
You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. Please tell me your name.
Massey.
You're here in 21 CF 2554AO, charged with battery, domestic by strangulation, aggravated battery on a pregnant person, and battery domestic violence. I'm going to appoint the Public Defender's Office to represent you. There is probable cause in this case. Your bond will be $5,000 on count 1, $100, $150 on count 2, $100 on count 3. I'm also going to place you on pretrial release with special conditions. You're not allowed to have any contact with the victim. Do you understand what that means?
Yes, ma'am.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. Were you two living together?
Yes, ma'am. It's my apartment.
All right, I'm going to order that you maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings, but you can't coordinate that through her. You understand that?
Yes, ma'am.
Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir.
Yes, ma'am.
Please tell me your name.
Joshua Smith.
You're here because a warrant was issued for your arrest in case number 21 CF 2504AO, charging you with aggravated battery on a pregnant person, battery domestic by strangulation, and false imprisonment. I'll appoint the Public Defender's Office to represent you. Ma'am, do you wish to testify this morning?
Yes.
Please raise your right hand to be sworn.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
State, you may inquire.
Good morning, ma'am. Can you please state your name for the record?
Teresa Taylor.
Can you speak up a little more?
Teresa Taylor.
Thank you. And what is your relationship to the defendant?
Boyfriend.
And are you afraid of him?
No.
If he were to get out of jail, would you be afraid of him?
No.
Were any drugs or alcohol involved in this altercation?
No.
Has anything like this ever happened before?
A false report that I made, yes. According to this one, too. I didn't even see him that night.
Wait, I couldn't hear what you said. Can you say that again, please?
I didn't even see him that night. I was intoxicated when I made the report.
Okay. And are you willing to call 911 if anything ever were to happen?
Yes.
That's all I have this time, Your Honor.
Does the defense wish to inquire?
So you said you were intoxicated when you made the report?
Yes.
Oh, no further questions, Your Honor. Based on that statement, Your Honor, would you be willing to give a lenient bond amount? I know he doesn't qualify for pretrial release.
I showed that he doesn't qualify for pretrial release, and he has previous convictions for domestic battery, burglary, domestic aggravated battery on a pregnant person.
No, I don't. No, I got.
Don't talk about
So at this time, sir, your bond will be $5,000 on count 1, $150 on count 2, $150 on count 3. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes.
Do you understand?
Yes.
You can't call her, you can't send a message through a friend or communicate through an app. You understand that?
Okay, but
Don't-
can I mention something?
No.
You can say anything you want. Everything you're saying is being recorded and can be
My
used against
rights
you.
was not read to me.
I'm sorry, what?
My rights was not read to me.
When you were arrested?
Yes. So I had to add that, and it's on my affidavit, so.
All right. Your attorney can file a motion about that in front of the trial judge.
Can I also say something?
Yes?
And I'm not pregnant either. Like I stated, it was a false report that I made. I was intoxicated. He wasn't even there.
Your Honor, based on that, she states that she is not pregnant. We would ask that there is no PC on an aggravated battery on a pregnant person. Based on the victim's statement here today.
Probable cause has already been found, counselor. I'm just going to set his bond conditions today.
But the victim states she's not pregnant, Your Honor.
Nope, not in, I was a victim on the other case too, and I wasn't pregnant either. So I'm telling you, I made a false report.
Ma'am, I don't know what to tell you. He was convicted of the other case.
No, he wasn't. It was against me, and it was dropped.
Okay, I don't know about that. I know what's in the criminal history that I have. That's all I know. So I'm still going to order that you're not allowed to have any contact with her at this time. You're not allowed to possess a weapon of any kind, firearm or ammunition. You understand?
Yes.
You're not allowed to return to 1900 Conway Road. Were you living there?
No,
All right, so you don't need to return there to gather belongings. All right, so no return
it's all a lie, like.
to that address. All right, your attorney can file a motion, sir. Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir. Thank you, ma'am. Please tell me your name.
Michael Curry.
You're here in case number 21MM1510AO, charged with battery domestic violence. I'm going to appoint the Public Defender's Office to represent you. There is probable cause in this case. He qualifies for pretrial release? What says the state?
Your Honor, I only see one prior battery DV, and since he does qualify for PTR, the state has no objection. The victim did state that she is afraid of the defendant, according to the contact that I believe pretrial services made with her previously. So the state would just ask for a no contact, since she's not present here today.
All right, so I'm going to place you on pretrial release. Special conditions are you're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You're not allowed to possess a weapon of any kind, firearm or ammunition. Were you living at this apartment?
Yes, it's my apartment, yes.
All right, I'm going to order that you maintain a separate residence. I'll allow one-time return with law enforcement officers to gather your belongings. But you understand if she's living there, you can't live there.
Yes, ma'am.
All right, good luck, sir. Please tell me your name.
James Drummer, ma'am.
Sir, you're here because a warrant was issued for your arrest in case number 21MM1515AO, charging you with assault, domestic violence. So there is probable cause. I'll appoint the public defender's office to represent you. Your bond is $1,000. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
All right. You're not allowed to return to the scene. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Good luck, sir.
Thank you, ma'am.
Please tell me your name.
David Harrison.
Sir, in case number 21MM132AW, you're charged with battery domestic violence and assault domestic violence. I'm going to appoint the public defender's office to represent you. There is probable cause. He qualifies for pretrial release. Does the state have any objection?
No, Your Honor, I believe the offense that he picked up against the same victim, the aggravated assault with a deadly weapon, was a few years ago, I believe. So if he otherwise qualifies and there's not a victim here, state has no objection.
All right, so I'm going to place you on pretrial release. You're not allowed to have any contact with the victim. Do you understand what that means? I'll order that you're to maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings if you need to do that.
Okay.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. Any other conditions the state would request?
No, Your Honor, I believe that's it.
All right, good luck, sir. Please tell me your name.
Marcus Johnson.
Sir, you're here in 21 CT 2478E, charged with driving while license suspended. Does the state have an offer in this case?
Yes, Your Honor, it's an adjudication, credit time served, and no driving without a valid deal.
Are you interested in accepting that?
What is it?
An adjudication of guilt, credit time served, and no driving without a valid driver's license.
Okay. What's up?
Ms. George, did you speak with them before court today?
No, Your Honor.
All right. Please raise your right hand, Mr. Johnson.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, sir. You understand that if you enter a plea of guilty or no contest today, you're going to be giving up your right to remain silent, your right to testify on your own behalf, your right to a jury trial when one is required, and to call witnesses to present any defenses you might have. We're not going to have a jury trial if you enter a plea today. You understand that?
Yes, ma'am.
You understand that if you're on probation, this plea could violate that probation?
Yes, ma'am.
You understand if you're not a United States citizen, this plea could subject you to deportation?
Yes, ma'am.
Has anyone threatened you or promised you anything to get you to enter this plea?
No, ma'am.
All right, sir. At this time, how do you wish to plead to the charge of driving while license suspended?
No contest.
I'll accept your plea of no contest. Before I do that, you didn't have the opportunity to speak to the defense about this, but you do understand that driving while license suspended is the type of charge that the more convictions you have, eventually it becomes a
I know it turns
felony.
into a felony.
Right, so you do understand that.
Ma'am.
So this is going to count as a conviction for you. You understand that?
Yes, ma'am.
Your Honor, I'm also aware that his IA information sheet doesn't have any history on it. He does have a prior Dwellis 20 CT 59 he was adjudicated for. So I believe this will be his second adjudication.
So mine says he has 2 prior driving while license suspended.
It would,
So I just want to make sure you understand that at some point, the state can charge this as a felony. So right now, as a first-degree misdemeanor, the maximum penalty is a year in jail or a $1,000 fine. But if it becomes a third-degree felony, your maximum penalty is 5 years in prison. You understand that?
Yes, ma'am. I understand.
Okay. Do you want to talk to him, Ms. George?
okay, Your Honor. He wants to accept the,
All right, so you still want to accept the plea offer?
Yes, ma'am.
Do you know what it'll take to get your license back?
$2,100.
All right. So at this time, you still want to enter a plea of no contest?
Yes, ma'am, because I gotta do a payment on my license anyway.
Okay. I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for
1 day.
1 day in jail. I'm not going to order you to pay a fine, but I have to order that you pay court costs.
Okay.
I'll give you a year to pay them, but you understand that
Yes,
this
ma'am.
could also suspend your license if you don't pay it.
Yes, I know.
All right, so you want to make sure you get all that done and talk to DMV right away.
Yes, ma'am, I'm going there today.
Okay, all right, sir, you have 30 days to appeal in writing. Good luck.
Yeah.
Please tell me your name.
Shane Tannehill.
In case number 2019 CT 7598E, a KPS was issued for your arrest for failing to appear for trial on a charge of driving while license suspended or revoked with knowledge. Your bond is $4,000. I'll appoint the Public Defender's Office to represent you. In case number 2019 CT 758AE, a KPS was issued for your arrest for failing to appear for trial on a charge of driving under the influence. Your bond on that is also $4,000, and I'll appoint the Public Defender's Office to represent you for both. It says trial.
Yeah. So it's Division 83, pretrial conference at 1:30 and 6:60.
All right, good luck.
Gotcha. 8:12.
Gotcha. This is already set. So it's all automatically set for trial?
It's set for pretrial conference.
Okay.
So you have to take up whether it's going to trial with the judge in that division.
Okay.
So talk to your attorney about that. Please tell me your name.
Audrey Michelle Ukenna.
You're here in 21 CT 346AW, charged with driving while under the influence. I'm going to appoint the Public Defender's Office to represent you. There is probable cause in this case. She qualifies for pretrial release. Any objection by the state?
No, Your Honor.
I see prior DUIs. Ma'am, I'm going to place you on pretrial release, but I'm also going to impose a monetary bond of $500. Your special conditions are you're not allowed to possess or consume any alcoholic beverages. You'll be subject to random alcohol screens while on pretrial release. You're not allowed to drive a vehicle without a valid driver's license. Do you understand?
Yes, ma'am.
All right, good luck. What happened with Yuri Souza?
Bonded, Your Honor.
All right. All right, so now we have arraignments. I have Erwin DeDios, 21MM238AO. He's represented by your office, Ms. George.
Not a plea, Your Honor.
Your Honor, we'll waive and enter plea, not guilty.
Division 63, pretrial conference, April 8th at 1 PM and 12C.
Next, I have Shavion McKnight, 21CT167AE. I'm going to appoint the Public Defender's Office. He's charged with driving while license suspended with
Bonded,
knowledge.
Your Honor.
Okay.
He bonded, was he given a new court date? You know? Thank you, ma'am.
Is the state ready for 33-day motions?
Yes, Your Honor.
All right, first, thank you, sir. First, I have Douglas Bronson, 21CF1081.
That case was just filed on yesterday.
Calvin Bronson, 21CF321.
Notice of non-filing.
Christopher Brown, 21CF1242.
Sorry, Your Honor, Calvin Bronson was the one we were withdrawing, the 33-day motion.
Oh, you're withdrawing it?
Mhm.
All right. Next, Christopher Brown.
Notice of non-filing.
Thomas Carlin, 20 CF 14040.
Notice of non-filing.
Kyle Ferretti, 21 CF 639.
It was filed yesterday, Your Honor.
Johnny Hightower, 21 CF 1143.
Notice of non-filing.
Romaine Humphrey, 21 CF 1252.
Notice of non-filing.
Willie Miller Jr., 21 CF 636.
It was filed and consolidated with another case.
Kayla Arriaga, 20 CF 14431.
It was filed yesterday.
And I have Yancey Fillmore, 21 CF 841.
It was also filed and sent down to county court.
All right, any other business before the court this morning?
No, Your Honor.
All right, court will be in recess.
Yes, ma'am. First Harris, Lewis. All right, tell me your name, sir.
Harrison.
Say your name.
Antoine Harrison.
All right, Mr. Harris, you are here in 2021 MM130AW. You were arrested for 2 charges. The first one was stalking, the second one is battery. I did review the charging affidavit in this case. I did find probable cause for your arrest. I'm going to release you on pretrial release in this case. Condition of your pretrial release, look at me, that you have no contact with the victim in this case. You're not returned to the scene of this location. You're not possessing any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You understand? Are you understanding me, sir?
I understand you, man.
All right, have a great day.
Like that way.
Good morning, sir. Tell me your name.
Franklin Bruce Rule, sir.
Mr. Ruth, you're here, is it Rule?
Rule.
Mr. Rule, all right. Mr. Rule, you're here in 2021 MM1518AO. You're arrested on a charge of trespass after warning. I did review the charging affidavit in this case. I did find probable cause for your arrest. State, is there an offer for Mr. Rule to resolve his case this afternoon?
Yes, Your Honor. It's an adjudication, credit time served, no return.
All right. Mr. Rule, do you want to accept that offer from the state of Florida?
Yes, sir, please.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
I do, Your Honor.
All right, put your hand down.
Thank you, sir.
Sir, you're here in 2021 MM 1518AO. You're for a charge of trespass on property after warning. That is a first-degree misdemeanor. It's punishable up to 1 year in the county jail and a $1,000 fine. Do you understand that? Do you understand?
Yes, sir.
All right, can you cover your nose for me? Thank you.
Slip it, I'm sorry.
No problem. Do you want to enter a plea of guilty or no contest to resolve your case today?
No contest.
Do you understand by accepting a plea of no contest, you give up the right to have a trial where the state had to prove your guilt beyond a reasonable doubt? You understand you give up the right to have an attorney appointed to represent you at a trial if you cannot afford it?
Beg your pardon, sir?
You understand you give up the right to have an attorney appointed to represent you if you cannot afford it?
Okay.
All right. At a trial, your attorney can challenge the state's evidence. They can question the state's witnesses. They can call witnesses on your behalf. Do you understand?
Yes, sir.
If there's a witness you wanted to call and that witness did not want to appear, the court can use a subpoena power to make that witness appear. Do you understand?
I'm sorry, sir. One more time.
If you wanted to call a witness to the court and that witness did not want to come to court, I can use my subpoena power to make that witness appear. Do you understand?
Okay, yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
Yes, a bipolar.
All right. Are you suffering from any of the symptoms of your bipolar disorder?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir, they have not.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Okay, yes, sir.
I did refute the charging affidavit in this case. I do find a factual basis for the entering of your plea. I accept your plea of no contest, find your plea is freely and voluntarily entered. I'll adjudicate you guilty of the charge. I'll give you credit for the 2 days that you spent in the Orange County Jail with 2 days credit time served. The court costs and costs of prosecution in this case are $273. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. Do you understand?
Yes, sir.
All right, have a great day, sir.
Thank you.
All right, tell me your name, sir.
Sean. William Gilmore.
Mr. Gilmore, you were arrested on a 2016 MM 4681 failure to appear warrant. The judge in that case set your bond at count one amount of $1,000 and $100 is to count two. State is going to ask you if you're going to offer to resolve Mr. Gilmore's case today.
There's no offer at this time, Your Honor. The case that he capiased on, it's set for a comp status hearing, so there's no offer at this time.
And I reviewed his file today. I didn't see a competency hearing.
There was comp issues. He has comp issues.
Okay.
Because I'm not sure I hear it's about Sean William Gilmore.
All right, sir.
Yeah.
You're gonna say your bond's are set. We're gonna appoint a public defender to represent you, get you in front of the appropriate judge to deal with your hearing, okay? Yes, ma'am.
Yeah, my son there had been arrested before.
All right, thank you, Mr. Gilmore. Have a great day.
Okay.
All right, good morning, sir. Can you tell me your name?
Darius Goodman.
I can't hear you.
Darius Goodman.
Mr. Goodman, you're here in 2021 CF 2544AO. You're arrested on two charges. The first one was grand theft of a motor vehicle. The second one is grand theft. The court did review the charging affidavit. In this case, it did find probable cause for your arrest. I want to say your bonds are set, in this case, in the amount of $1,000, on each count. I'm going to appoint a public defender to represent you in this case. Condition of your bonds to have no contact with the victims in this case and not return to the scene, the location where this incident happened.
My bond is 200, right?
It's $2,000.
$2,000?
Yep, 1,000 on each count. All right.
Thank you.
I did have an opportunity to review your other court cases.
He's gone.
That's fine. I'm not taking any action on his
Okay,
other
thank you,
cases.
Your Honor. Tell him it's okay. He's not taking action.
I'm appointing a public defender to represent him.
Thank you, Your Honor.
All right. Can you tell me your name, sir?
Kieri Hines.
Mr. Hines, you're here in 2021 CF 2469AO on charges of sexual battery on a child under the age of 12 years old. The judge signing your warrant has previously found probable cause for your arrest. State, what are you asking that I do as to his bonds in this case?
Your Honor, since it's a PBL, the state's asking for no bond.
It's actually a life felony. It's a capital offense. Ms. George, I want to point a public defender to represent you in Mr. Hines' case.
I'm
Are you
sorry.
making any argument as to the state's request?
What did you request? I'm sorry, I couldn't hear
This
you.
is a sexual battery on a child under the age of 12 years old. Is a capital sex bat.
No, Your Honor, we reserve the right to have arbitration.
All right. All right, sir, I want to hold you at no bond in this case. Condition of your bond is if you are to be released and while you're here at the Orange County Jail, so you have no contact with the victim or the victim's family. You're not to return to the scene of this location where this incident happened. You are to possess no weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. All right.
Just a moment.
All right. Thank you, sir. Have a great day. All right. Good morning, ma'am. Can you tell me your name?
Shabelle Osborne.
Hear you.
Shabelle Osborne.
Ms. Osborne, you're here in 2021 CF 2542AO on a charge of grand theft of a motor vehicle with a mask. The court did review the charging affidavit. In this case, I did find probable cause for your arrest. Was she ever interviewed?
She was, Your Honor. I gave you an updated.
Okay. There we go. All right, ma'am, I'm going to release you in this case on pretrial release. Conditioning your pretrial release and not return to the scene of this location, have no contact with any victims or witnesses. You understand? All right. We'll appoint a public defender to represent you. Have a great day.
Your Honor, that's straight PTR, correct?
Yes, ma'am. This is another one. Was he interviewed? Our next person? You have updated for him?
No, I don't.
Okay. All right, sir. Don't tell me your name. Don't cover your face. Thank you.
Hi, my name is Alexander Paniagua.
Mr. Payapa, you are here in 2021 CF 2518AO on a charge of criminal mischief of $1,000 or more. I did review the charging affidavit in this case. I did find probable cause for your arrest as to that charge. I'm going to release you on pretrial release in this case. Condition of your pretrial release, you had no contact with any victims or witnesses in this case. You are to not return to the scene of this location where this incident happened. Do you understand that?
Okay, what am I being charged for?
Criminal mischief.
What happened? Like, I just want to make sure you know that what I know.
All I know was on this charging affidavit, the sworn charging affidavit, at one point the public defender, is anything you tell me is being recorded and can be used at a later time against you. So I suggest you don't tell me anything other than talk to Ms. George if you have a question about what's going on.
Okay. I mean, my car got started burning.
All right. All right, have a great day, sir. Good morning, sir. Tell me your name.
Mr. Hector.
Is it Etcher?
Hector.
Mr. Etcher. Mr. Etcher, you're here in 2021 MM 131AW for a charge of trespass on property after warning. I did review the charging affidavit in this case. I did find probable cause for your arrest. Says there an offer for Mr. Etcher to resolve his case today.
Yes, Your Honor, to withhold credit time served, no return.
Can I ask why it's a withhold?
I didn't see any prior trespasses. I haven't pulled CCIS.
Okay. All right, Mr. Ecker, the state of Florida is offering you a withhold of adjudication of guilt and court costs. You want to take that offer today?
Excuse me?
You want to take the offer of a withhold of adjudication of guilt, credit for the 2 days that you spent in Orange County Jail, and court costs? You want to take that offer? It's up to you. You going to resolve the case today, or we can resolve it another time?
Yes, please.
I can't hear you.
Yes, please, resolve it today.
All right. Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, sir, you're here in 2021 MM 131AW on charge of trespass on property after warning. That is a first-degree misdemeanor. It's punishable up to 1 year in the county jail and a $1,000 fine. Do you understand that?
Yes, I do.
Do you want to enter a plea of guilty or no contest to resolve your case today?
No contest.
No, no contest.
All right. Do you understand by entering a plea of no contest in this case that you're given the right to have a trial in this matter? You understand that?
I do.
You understand you're given the right to have an attorney appointed to represent you at a trial?
I do.
At a trial, your attorney can challenge the state's evidence, they can question the state's witnesses and call witnesses on your behalf. Do you understand that?
Yes, I do.
If there's a witness you wanted to call and that witness did not want to come to court, the court can use subpoena power to make that witness appear. Do you understand?
Yes, I do.
Are you under the influence of any drugs, alcohol, or medication?
No, I'm not.
Have you now or in the past been diagnosed with a mental health illness?
No, no.
Has anybody forced, threatened, or coerced you to enter this plea?
Excuse me?
Has anybody forced, threatened, or coerced you to enter this plea?
No.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation. Do you understand if you're not a United States citizen, this could subject you to deportation?
Well, I'm a U.S. citizen. I don't know.
As a yes or no question, do you understand? You understand what
Yes, I understand.
that could be a result? Do you understand that it seems that in your past you've been convicted of a priorly sexually motivated or sexually violent offense, that if sent to prison, that this plea could also be used against you in a human rights proceeding? Yes?
Yes.
Okay. All right, sir, I did review the charging affidavit in this case. I did find a factual basis for the entering of your plea. I'll accept your plea of no contest. Find your plea is freely and voluntarily entered. I will give you credit. I will withhold adjudication of guilt. I'll give you credit for the 2 days that you spent in the Orange County Jail with 2 days credit time served. The court cost of prosecution in this case are $273. I'll reduce those costs to judgment in this case. You have 30 days from today's date to appeal your judgment sentence in writing. You also have 48 hours from the time you're released here to report to the sheriff's office to report as sexual violence or sexually violent or offender or sexual predator. All right, have a great day, sir. Not ordering that. I just have to, just giving him free information.
Your Honor, next on the list, Gibson Medical.
All right. Medical. All right, this is Brittany Gibson. I'm going to appoint a public defender to represent her in 2021 MM 1501AL.
We'll waive, Your Honor.
All right, I'm going to release her own recognizance as to this charge. RR, yeah, say it. I'm RR here. Yes, I did. All right. Can you tell me your name, sir?
Good morning, Your Honor. My name is Joseph Albert Inga.
Is it Egan?
Inga?
Inga. All right, cover your face. There you go. Mr. Inga, you're here in 2021 MM 1516AO on charges of possession of drug paraphernalia, trespass on property after warning, and possession of cannabis of less than 20 grams. I did review the charging affidavit in this case. I did find probable cause for your arrest. State, do you have an offer to resolve all of his cases, including the 2021 MM 1414AO case?
Yes, Your Honor. So for the 1516 case, we're going to be filing or doing a no information to the drug paraphernalia and the cannabis.
Okay.
And a plea to the trespass as a withhold, credit time served, no return. And in regards.
Wait a second, wait. Excuse me. All right, so you find, if he's resolving the case, there's no point in doing a no information. It's not process the charge. Or just, it's up to you. I'm just like, because that means if you say no information, that means you can file on him later on.
It just hasn't been filed on yet, so I couldn't know the process.
Yes, but if he's resolving it as a part of a resolution, then I think the term we should use is either dismiss or null process the charge. So he has a conclusionary kind of result in his plea.
Thank you, Your Honor.
And as to The 21 414, the offer is a withhold, court cost no return, and cost investigation to OPD in the amount of $39.22.
$39.22 to OPD?
Yes, Your Honor.
All right. And how many days does he have on the petty theft?
I will have to check, Your Honor, one
All
more.
right. All right. And now, sorry, I didn't mean to cut you off, because is on the trespass is adjudication of guilt or withhold?
The trespass was also a withhold.
All right. All right. So, Mr. Inga, I wanted to explain to you like this. The state's offering you, in the case you're arrested for, the case you're in front of me today that you're arrested on, is to dismiss or drop the drug paraphernalia and the cannabis charge, and for you to plead to the trespass charge, and the offer is a withhold adjudication of guilt and court costs in the amount of $273. You also are out on bond on the petty theft case, where the offer is a withhold adjudication of guilt, credit time served. You have a cost of investigation to the Orlando Police Department at $39.22. Do you want to take that global resolution to deal with all your cases that you're in front of, that you have with us today?
Yes, I would like to take all of them. I just want to be clear on the fines.
Say it.
The fines
It's $273 on each case,
on each one individually or total?
in each one individually.
And when is that owed?
I'll give you a year to pay it.
Oh, thank you. Okay.
Yes, 2
Thank you, Your Honor.
2 days? All right. All right, so you raise your right hand to be sworn in? You solemnly swear or affirm the testimony you're going to give in this matters, the truth, the whole truth, nothing but the truth, so help you God.
Yes, I do.
All right, sir, you are here in 2021 MM 1516AO on a charge of trespass. That is after warning, I'm sorry, that's a first-degree misdemeanor, is punishable by 1 year in the county jail and a $1,000 fine. You're also here in 2021 MM 414AO on charge of petty theft. That is a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. Do you understand that?
Yes.
Do you want to enter a plea of guilty or no contest to resolve these two cases?
No contest?
All right. Do you understand by entering a plea of no contest, you have the right to have a trial where the state will have to prove your guilt beyond a reasonable doubt in each case?
Yes.
You understand you have the right to have an attorney represent you in each trial?
Yes.
At that trial, their attorney can challenge the state's evidence. They can question the state's witnesses and call witnesses on your behalf. Do you understand that?
Yes, I do.
If there was a witness you wanted to call and that witness did not want to come to court, the court can use subpoena power to make that witness appear. Do you understand?
I didn't hear what you said the last time.
If there was a witness you wanted to call and that witness did not want to come to court, I can use my subpoena power to make that witness appear. Do you understand?
Yes, I do.
Do you understand you're waiving your right to remain silent as to each charge?
Yes.
Are you under influence of any drugs, alcohol, or medication?
No, I'm not.
Have you now or in the past been diagnosed with a mental health illness?
Yes, I have.
What was that mental health illness?
I got diagnosed bipolar disorder.
All right. Are you suffering from any of the symptoms of your bipolar disorder right now?
No, I'm not.
All right. Has anybody forced, threatened, or coerced you to enter this plea?
No.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes.
All right. All right, sir. In 2021 MM 1516AO, I did review the charging affidavit in this case, and I do find a factual basis for the charge of trespass on property after warning. The court will withhold adjudication of guilt as to that charge. I will find that your plea is freely and voluntarily entered. I'll give you credit for the 2 days that you spent in the Orange County Jail with 2 days credit time served. The court costs and cost of prosecution in that case are $273. As to 2021 MM 414AO, the court did have an opportunity to review your charging affidavit in chambers this morning. I did find a factual basis for the entry of your plea as to that case. I want to withhold adjudication of guilt, find that your plea is free and voluntarily entered. I'll give you 2 days credit with 2 days credit time served. The cost of investigation in that case is $39.22 to the Orlando Police Department. The court costs and cost of prosecution are $273. The totals, I will combine these two cases for payment. I'll give him 1 year from today's date to make that payment direct to the clerk in full. You have 30 days to appeal your judgment and sentence in each case. And state you have announcements as to the other two charges in 2021 MM 1516AO.
Yes, Your Honor. As to count 1 and count 3, state announces a no pros.
All right, sir. Have a great day.
Thank you, Your Honor.
Thanks, guys. All right, this is Mr. Kucera in 2021 MM 1519AO. I want to appoint the public defender to represent him.
We'll waive, Your Honor.
Going to release him on his own recognizance as to this case. Even though he has a prior violation of probation from 14 years ago, almost now at this point. He has no failure to appears. Tell me your name, ma'am.
Crystal Miles.
Ms. Miles, you are here in 2021 MM 1503AO on charge of possession of drug paraphernalia. The court did review the charging affidavit. In this case, I did find probable cause for your arrest.
Your Honor, state already filed and no information on this case.
I have that. Did you e-file it or did you hand it up to the ladies here?
I filed it when, in between sessions, but I'll print out another copy right now.
I was gonna say, did you also want to know, did you e-file it or did you like?
It was e-filed, yes, Your
E-filed, okay, all right. Okay. All right, ma'am, I'm gonna RR you as to that charge. I'm not gonna take any action on your 2020 CF 14724AO case.
Okay, that's fine.
Have a great day, ma'am. Actually, the state, you realize that, that other charge came in as a regular Burke advance. It's actually charged as a PBL now, but I don't know if you guys want to take any, change any bonds on that. But no, never mind. It's us. I didn't know if you guys were aware of that. All right.
For conveyance.
All right, tell me your name, sir.
Thomas Ward.
Mr. Ward, you're here in 2021 MM 1508AO on charges of resisting officer without violence and trespass in the occupied structure, refusal to leave. The court did review the charging affidavit. In this case, I did find probable cause for your arrest. States an offer to resolve Mr. Ward's cases.
Yes, Your Honor, to withhold credit time served, no return. And the reason for it again is he doesn't have no prior trespasses.
He just released from DOC in October of last year. I was trying to, I mean, if that's gonna be your stance, I mean, I get it, but I'm just trying to make sure we're looking at this as a whole picture, not just whether he has trespass convictions or not.
Yes, Your
All
Honor,
right.
at this time, that's.
All right, Mr. Ward, the state of Florida is offering you a withhold of adjudication and guilt and court costs as to these two charges. You want to take that offer to resolve your case?
Yes, sir.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Sir.
All right, sir, put your hand down. Sir, you're here in 2021 MM 1508AO on charges of resisting an officer without violence, trespass in an occupied structure, refusal to leave. Both of those are first-degree misdemeanors. Both of those are punishable by 1 year in the county jail each and a $1,000 fine each. Do you understand that?
Yes, sir.
Do you want to enter a plea of guilty or no contest to resolve your case today?
No contest.
It's up to you.
No contest.
No contest.
You understand by entering a plea of no contest, you give them a certain constitutional rights. So one of them is to give up the right to have a trial where the state had to prove your guilt beyond a reasonable doubt.
Yes, sir.
You understand you give them the right to have an attorney appointed to represent you at a trial.
Yes, sir.
At a trial, your attorney is challenging the, sorry. You understand your attorney can challenge the state's evidence. They can question the state's witnesses and call witnesses on your behalf. You understand that?
Yes, sir.
There's a witness you wanted to call and the witness did not want to appear. The court can use a subpoena power to make that witness appear. Do you understand?
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
Then or now?
Now,
No, sir.
has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes, sir.
You understand that since that you were convicted of a sexually motivated, sexually violent offense, that this plea at a later date, if you're sent to the prison again, can be used in a human rights proceeding as an aggravator.
Yes, sir.
I did review the charging affidavit in your case. I did find a factual basis for the two charges you're facing. I'm going going to accept your plea of no contest, find that your plea is freely and voluntarily entered. I will withhold adjudication of guilt, give you credit for the 2 days that you spent in Orange County Jail with 2 days credit time served. The court costs the cost of prosecution in this case of $273. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You got 30 days from today's date to appeal your judgment and sentence in writing. Just some free advice, you also have 48 hours to report to the sheriff's office as a sexual predator or sexual offender, all right?
Sir?
You have 48 hours to get to the sheriff's office. That's just some free advice. I'm not ordering you to do that, but
Oh,
the
yeah.
law says you need to go report within 48 hours of being released from this jail.
Yes, sir, I already know.
All right, have a great day.
So do you want me to write that on order?
I can't order him to do it because he's not under any release conditions. I'm giving him some free legal advice.
Do you want it on the order?
Tell him what the law says. You don't have to put it on the order. If you feel more comfortable, I want you to. No, ma'am. I don't think I need you on the order. All right. Sir, tell me your name.
Charles Wilkes.
Mr. Wilkes, you're here in 2021 MM 1506 AO on a charge of petty theft. The court did review the charging affidavit. In this case, I did find probable cause for your arrest. Says an offer for Mr. Wilkes to resolve his case today.
Yes, Your Honor, withhold credit time served.
All right. All right, sir. State's offering a withhold adjudication of guilt, credit time served. Do you want to take that offer today?
Yes, sir.
Can you raise your right hand to be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth to help you God?
Sir.
All right, put your hand down. All right, sir. You're here in 2021 MM 1506 AO on charge of petty theft. That is a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. Do you understand that?
Yes, sir.
Do you want to enter a plea of guilty or no contest to resolve your case today?
No contest.
Do you understand by entering a plea of no contest, you give the right to have a trial in this matter?
Yes, sir.
You understand you give the right to have an attorney appointed to represent you at a trial?
Yes, sir.
At a trial, your attorney can challenge the state's evidence. They can question the state's witnesses and call witnesses on your behalf. Do you understand that?
Yes, sir.
If there's a witness you wanted to call and that witness did not want to appear, the court can use subpoena power to make that witness appear. Do you understand?
Sir.
Are you under the influence of any drugs, alcohol, medication?
Sir.
Have you now or in the past been diagnosed with a mental health illness?
Sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes, sir.
All right, sir, I did review the charging affidavit in this case. I did find a factual basis for the entering your plea. I'll accept your plea of no contest, finding the plea is freely and voluntarily entered. I'll withhold adjudication of guilt. I'll give you credit for the 2 days that you spent in the Orange County Jail with 2 days credit time served. The court calls the cost of prosecution in this case of $273. I'll give you 1 year from today's date to pay that money directly in full. You have 30 days from today's date to appeal your judgment and sentence in writing. Have a great day, sir.
Sir.
All right. Tell me your name, sir.
Jimmy Ray Williams.
Mr. Williams, you're here in 2021 MO 1520 on charges of open container. I did review the charging affidavit. I did find probable cause for your arrest. State, do you have an offer that you conveyed to Ms. George for all his cases?
Your Honor, I did not see the petty theft.
Yeah, he's charged with petty theft with 1 prior theft conviction. He's represented by the Public Defender's Office in 2020 MM 222A.
You'll give me 1 second.
Because we're not gonna do it anyway.
No, Your Honor, there's no offer at this time. But and in regards to the open container, it's adjudication credit time served. You want to take an offer right now?
All right, sir.
Armstrong, I just want you to know I'm not.
There's no offer to resolve your other open misdemeanor case, but do you want to resolve your open container case with the city?
Yes.
All right, sir, can you raise your right hand to be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, sir, you're here in 2021 MO 1520 AO on charge of open container. That is a second degree misdemeanor, punishable up to 60 days in the county jail and a $500 fine. Do you understand that?
Yes, sir.
Do you want to enter a plea of guilty or no contest to resolve your case today?
No contest.
You understand by entering a plea of no contest, you're given the right to have a trial where the state had to prove your guilt beyond, the city had to prove your guilt beyond a reasonable doubt. You understand you're given the right to have an attorney appointed to represent you at that trial. Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation. All right, sir, I did review the charging affidavit in this case, so I did find a factual basis for the entering your plea. I'll accept your plea of no contest in this case and find your plea is free and voluntarily entered. I'll adjudicate you guilty of the charge. I'll give you credit for the 2 days that you spent in the Orange County Jail with 2 days credit time served. The court costs in this case are $223. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal, 30 days from today's date to appeal your judgment sentence in this case. I'm not going to take any action on your 2020 MM 222 AE case. All righty. All right, this is Jonathan Armstrong at 2020 MM 8027AO. I want to appoint the public defender to represent him.
We'll waive, Your Honor.
He has a failure to appear warrant. His bond's at $250. He'll remain as set. All right, tell me your name, sir.
Errol Lee Arango.
I can't hear you.
Errol Lee Arango.
Mr. Arangelo, you're here in 2021 CF 2538AO on charges of unlawful use of a two-way communication device, solicitation to sell or deliver heroin, and possession of fentanyl. The court did review the charging affidavit in this case. It did find probable cause for your arrest. I want to stay your bonds in count one, amount of $150, $15,000 as the count two, and $150 as the count three. I'm going to,
Your Honor, regarding the 21 CF 154, the state would request that you take no action.
why?
No information has been filed on it yet. He was just arrested 1-4 and no information has been filed.
He was arrested on 1-5 or bonded out on 1-5, charges of trafficking of fentanyl, possession of cocaine with intent to sell and deliver, possession of methamphetamine with intent to sell and deliver, and possession of drug paraphernalia. What about in the law that tells me that I should not take action on his case?
Just given that it hasn't been filed on, the state hasn't
All right.
made a
Well,
decision.
Let's deal with the case we're here for first. 2021 CF 2538AO, with a condition of your bond, not possessing any drugs or alcohol without a valid prescription. If you are released, you'll be subject to random drug and alcohol testing at your expense. As to 2021 CF 154AO, of course, going to finding probable cause that you have committed a new law offense while out on release. The court is going to revoke that bond. We're going to set a new bond at $0 on each of those counts. I'm going to appoint a public defender to represent you in both cases and get you in front of the appropriate judge to have an appropriate bond hearing.
I don't understand. For the bond that I was previously out on,
Yes, sir.
we are revoking that bond?
Yes, sir.
So how can, I can't, what would I have to do about that one?
You talk to your public defender, call the number on the piece of paper right there to get you in front of the judge.
So I don't have a bond on that, is what you're saying?
That's correct.
Okay.
The law tells me that if you are found to have probable cause to commit a new law offense while out on release.
I wasn't in possession of any drugs in that case.
Yeah. Have a great day, sir.
Step out that way.
Your Honor, Banner, he refused court.
All right, this is Mr. Banner in 2021 CF 2549AO. I'm going to appoint a public defender to represent him.
We'll waive, Your Honor.
All right. I did review the charging affidavit. In his case, it did find probable cause for his arrest. We're going to appoint I appointed a public defender. I'm going to stay his bonds in count one, amount of $15,000 and $500 as to count two. I'm going to make a condition of his bond that he not possess any drugs or alcohol without a valid prescription.
Your Honor, we would just ask that you take no action on his bond case.
Well, I'm trying to figure out, is his total bond $1,450?
I'm sorry.
I was trying to figure out what his total bond was. I didn't get a chance to look that up.
His old case?
Yes. I don't even know how they did that. Just
It looks
1,000.
like it's just 1,450.
All right.
1,000 on the burglary and 150 on each other count.
Okay. All right, the court's going to revoke that bond. We're going to set new bonds in his case. In count one, we're going to set bond amount of $3,000. Count two, $500. Count three, $500. Count four, $500. Count five, $500. Condition on that bond, no return to the scene, the location, no contact with any victims or witnesses in that case.
They only filed on one of the criminal mischief charges.
So I will, in count five, I'll RR him. Count five is RR. No, he's not, he's technically out on bond, but it didn't file on the case. Yes, yes, ma'am. Good morning. Good afternoon now. Good afternoon, ma'am. Tell me your name.
Danielle Brown.
Ms. Brown, you are here in two matters. The first one, they're both failure to appear warrants. The first one is 2020 CF 4436AO. The judge in that case set your bond at $0. And you were also here in 2020 CF 4431AO. The judge in that case set your bond at $7,500. I'm going to appoint the public defender to represent you in all your cases and get you. Oh, sorry. You have a private attorney?
Yes.
All right, so you gotta let Ms. Dominguez, Ms. Dominguez know that you're here in the Orange County Jail, so she can get you in front of the appropriate judge and get you in a bond hearing, okay? All right, so I give her a call. All right, have a great day, man. All right, tell me your name, sir.
Brandon Church.
Say your name?
Brandon Church.
All right, Mr. Church. One second. You are here in 2021 CF 2506AO on charge of possession of cocaine with 1,000 feet of a convenience with intent to sell or consent to sell and deliver. Actually, it's also called, this messed up, sorry. Possession of cocaine with intent to sell and deliver within 1,000 feet of convenience business. You're also here on charge of possession of cocaine. All right. The court did review the charging affidavit in this case, did find probable cause for your arrest. I'm going to stay your bond in count one, amount of $10,000, count two, an amount of $1,000. Condition of your bond, not possess any drugs or alcohol without a valid prescription. You'll be subject to random drug and alcohol testing at your expense. You're out on bond in 2020 CF 14706AO. In that case, the court is going to revoke that bond. We're going to set a new bond at $0 in that case. I'm going to appoint the public defender to represent you in both matters. Have a great day, sir.
Encino Derek, you refuse court.
All right, Mr. Cancino is 2021 CF 2543 AO. Going to appoint the public defender to represent him.
We'll waive, Your Honor.
All right. All right. Ms. Davis, you gonna get mad if I put him on pretrial release?
I'm sorry?
You gonna get mad if I put him on pretrial release?
Not at all, not at all. Your
All right. All right, I want to release him on straight pretrial release in this case. Conditions of pretrial release, no contact with any victims or witnesses, no return to the scene, the location where this incident happened. All right, is this Mr. Coughlin? Or
Coughlin PTR, Your Honor.
how? Oh, so the judge on the FTA warrant saw him?
That's, I received the email
Okay.
that
I don't need to address him then.
for the PTR from downtown.
Yeah, I don't have. I'm not taking any action. If he needs to be seen, I'll appoint a public, he's represented by the public defender's office, I'm guessing? Well, we won't appoint a public defender to make sure that he doesn't get lost at the jail. A private attorney? Okay, well, that's even better. All right, sir, tell me your name.
Sean Cronin.
Is it Cronin?
Cronin.
Cronin. Cronin, you're here in 2020 CF 13153 AO on a failure to appear warrant. The judge signing your warrant set your bond at $3,000. Your bond remained at $3,000. I want to appoint the public defender to represent you in this case. Have a great day, sir. All right. Well, I was going to talk to Ms. Davis about this. If I release her on pretrial release, when they release her,
That'll be a little complicated, Your Honor, because, she was never interviewed. Her fingerprints were never taken, and she's in the hospital. There's no way we can get her.
No, I was asking. If there's a possibility I can do that because there's nothing in her criminal history that was violent. It was all drugs, theft, and prostitution, basically. So criminal history told me that she probably should qualify for pretrial
Oh,
release.
she's on probation in Broward County. If you look on the second page.
Oh. There's a section in the front. All right, we will reset her for 24 hours from release from the hospital. All right, good afternoon, sir.
How you doing, sir?
Can you tell me your name?
Rodney Lee Goodman.
All right, Mr. Goodman, you're here in two matters. The first one is 2021 CF 2499 AO. You're here on a charge of possession of methamphetamine. I did review the charging affidavit. I did find probable cause for your arrest. I'm going to set your bond in that matter in an amount of $250. Yes, ma'am. Condition of your bond is you're to not possess any drugs or alcohol while a valid prescription. You will be subject to random drug and alcohol testing at your expense. You're also here for an out-of-county warrant.
Yes.
From, I believe, I wanted to say Seminole. Let's make sure. Volusia County. The judge in that case set your bond amount of $250. We'll appoint the public defender to represent you in this case.
Yes.
Have a great day, sir.
Yes.
Harrison in mental health
All right, this is 2021 CF 2513AO. Mr. Alex Harrison, one appointed public defender to represent him.
We'll waive, Your Honor.
I did review the charging affidavit. In this case, I did find probable cause for his arrest. I'm going to stay his bonds in the amount of $1,000. Condition of his bond, no contact with the victim or any witnesses, no return to the scene of the location. All right,
Your Honor, I believe there's a second case with Mr. Harrison.
there was, no, not today. He has a lot of cases, but the only one I have was the one criminal mischief.
Okay.
Yeah, I mean, he's been seen on several other cases, but that's the only one I saw was that one.
Yes. 20 CF 1824. Yes. 1824.
He was already seen on that.
It's 5 charges.
Yeah, he was seen. Did you ask me to take action on those other cases? Or?
I don't believe so.
Is he out on? Is he even out on those other cases?
No, he's still in jail.
Yeah, that's what I was saying. No, all right, sir. Tell me your name.
Javian Johnson.
All right, Mr. Johnson, you're here in 2021 CF 2498AO on you're arrested for a charge of aggravated battery, great bodily harm, or with a weapon. The court did review the charging affidavit in this case. State, did I miss something? Did they even talk about any injuries sustained by the victim? I know you're struck in the face and then struck in the left hip or something, but. And also the weapon's a paintball gun, which I don't think can qualify as a deadly weapon based on any case law I've read. It's not even like a BB gun that can even penetrate the skin.
Your Honor, can I have 24 hours?
Yeah, I can do that.
Additional information from the officer?
All right, I will allow you, give the state 24 hours to give me the PC for aggravated battery. Did find probable cause for battery. So we'll, yeah, reset them for tomorrow. If he does bond out though, we'll make it no contact with any victims or witnesses, no contact with any co-defendants. And yeah, I'm resetting it for tomorrow to give him 24 hours. I'm not gonna hold him because I don't think I can.
He won't be able to bond out unless you take no action on the out on bond case.
Yeah, I'm not doing anything as to we're gonna wait till tomorrow about the resetting everything for tomorrow. But I just want, just reset it for tomorrow. Don't worry about it. Just leave it. I told Judge Gibson about it. Now she was gonna be covering, or she want to bring him back in the morning. And I'll do it in the morning. Yes, appointed public defender representative. I forgot about that, Ms. Davis. Thank you for pointing that out. Yes, just, can I keep this with his paperwork? For tomorrow. I guess petty up here, man. All right, sir, tell me your name.
Wayne Bethard Jones.
All right, Mr. Jones, you're here in 2020 CF 10069AO. You're arrested on a failure to appear warrant. The judge signing your warrant set your bond at $0. I want to appoint a public defender to represent you in this case and get you on to your next court date and possibly a bond hearing.
Yes, sir.
All right, have a great day, sir. Can you tell me your name, ma'am?
Hi, you might have to talk a little.
We have some hearing devices. Give me 1 second. Oh, excuse me. All right. Can you tell me your name, ma'am?
Sabrina Kemp.
Ms. Kemp, you're here in 2021 CF 1930AO on charge of grand theft motor vehicle. The judge signing your warrant has already found probable cause for your arrest. I want to stay your bond in the amount of $1,000. Condition of your bonds had no contact with the victim in this case, no return to the scene of the location where this incident happened. I appoint a public defender to represent you. Don't tell me anything about your case because you're being recorded. If you have a question, you can ask Ms. George.
I was going to see if I could do, if I could go ahead and do like maybe a pretrial release or ROR. Sir, I really don't have nobody but myself. I was in the midst of moving and I have a job interview on Tuesday and I have a dog at home alone. I have responsibilities outside of here that only that I can handle. And I was just going to wonder if you could pretrial release.
You don't qualify for either. Looks like you have prior failure to appear and you have an open case in Lake County in 2021 MM 615AO for a theft. So you don't qualify for any of those types of releases. So I'm gonna say my order is set. Have a great day.
A $1,000 bond.
Yes, ma'am. All right, sir, can you tell me your name?
Christopher John Leon, sir.
All right, Mr. Leon, you're here in two matters. The first one is 2021 CF 2532AO. You're here for a charge of grand theft motor vehicle. You're also here in 2021 CF 2533AO on charge of driver license suspended, possession of Xanax, possession of a prescription drug without a prescription, resisting officer without violence, and possession of drug paraphernalia. I did review the charging affidavits, even though short. Did provide a probable cause for each of these offenses. I'm going to, in 2021 CF 2532AO, I'm going to stay your bond in the amount of $1,000. Condition of your bond is that you had no contact with any victims or witnesses in that case. In 2021 CF 2533AO, I'm going to stay your bond in account one, the amount of $2,500. $150 is account two, $100 is account three, $100 is account four, $100 is account five. Condition of that bond is you had possessed no drugs or alcohol without valid prescription. Be subject to random drug and alcohol testing if you are released. You are out on bond in 2021 CF 1341AO for another grand theft motor vehicle. The court is going to revoke that bond. We're going to set a new bond at $0 in that case. I want to appoint the public defender to represent you in all three cases. Have a great day, sir. All right, I had Lopez bonded, Lori bonded, and we should be on to Pilgrim as my next person. All right. Tell me your name, sir. All right, Mr. Pilgrim, you're here in 2021 CF 2541AO on charges of grand theft motor vehicle. I did grand theft motor vehicle, possession of fentanyl, and driving while license suspended as an habitual traffic offender. I did review the charging affidavit in both cases. I did find probable cause for all three charges. I'm going to set your bond in count one in the amount of $3,000. I'm going to stay your bond in count two and three in the amount of $150. Condition of your bonds, do not possess or consume any drugs or alcohol without a valid prescription. You'll be subject to random drug or alcohol testing at your expense. I'll give you a 30-day grace period for any narcotics you may have in your system. But alcohol testing will happen immediately. I want to appoint the public defender to represent you in this case. Have a great day, sir. All right, Rodriguez bonded. Tell me your name, sir. Mr. Sewell, you're here in 2020 CF 12770 AO on 2 counts of paid theft with 2 prior theft conviction. The judge signing your warrant in this case is set your bond in an amount of $1,000 on each count. Condition your bond, no contact with any victims or witnesses, no return to the scene of the location. One point the public defender to represent you. Have a great day, sir.
I'm sorry, Your Honor, this was Demetrius?
I had Demetrius, Sewell, I only had 1 warrant for, oops, I'm sorry. Apologize. I only saw the 770. I thought we were done with that. All right, apologize. All right, so you're also here in 2020 CF 12623 AO. In that case, you'd be in charge of 3 counts of petty theft with 2 prior theft convictions. The judge signing your warrant set your bond amount of $500 and $100 as to those counts, conditions of those bonds, no contact with any victims or witnesses, no return to the scene of the location. And you also have a Seminole County case. Let me finish. You got a Seminole County case on a county warrant for a grand theft. The judge in that case set your bond amount of $3,000. Same conditions, no contact with any victims or witnesses, no return to the scene of the location.
Seminole County case.
Yes, sir. And Seminole County, 2021 CF 315 AO.
And that's it, just a grand theft?
That says grand theft.
So I got 5 petty thefts and 1 grand theft?
1, 2, 3, 4, 5. Yep, what you're in front of me for today, yes, and then 1 grand theft. It looks like you have an old case, 2020 CF 12670 AO. I don't know what's going on with that case. Is he out on that case or? 12670?
I haven't had an open case since February of last year.
He's being seen on that today.
He's not being seen on that today, right?
He's being seen on that today.
On the 7, okay, all right. Wait. Oh, here it is, I found it, there we go. I'm sorry, yep, you are here on that case as well, 2020 CF 12670 for a charge of grand theft. The judge in that case set your bond amount of $2,500. Condition of your bond, no contact with any victims or witnesses, no return to the scene of the location. So you got 1 grand theft here in cover your face. You got 1 grand theft here in Orange County and 1, 2, 3, 4, 5 petty theft with 2 prior theft convictions. And then you have another grand theft case in Seminole County.
So I have 1 grand theft case in Seminole, and I have 1 grand theft here with 5 petty thefts?
Correct. I'm going to appoint a public defender to represent you in all your cases. Have a great day, sir. All right, tell me your name, sir.
Joseph Eugene Smith, sir.
All right, Mr. Smith, you're here in 2021 CF 2180 AO on charge of battery with a prior battery conviction. The judge signing your warrant set your bond amount of $1,500. Additionally, your bonds is you'd have no contact with the victim, no return to the scene, possess no weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release.
Sorry.
You are out on bond in 2020 CF 3789 AO and 2020 CF 3790 AO. In those cases, the court is going to revoke those bonds. They're going to set new bonds at $0. I want to appoint a public defender to represent you in all 3 of your cases, get you on to the appropriate judge for a bond hearing. Have a great day, sir. See, Ms. Davis? There's this line up here. It says state probation. Put somebody gonna write in the back, oh, she on Broward County probation, when there's a line up here that says state probation. All right, sir, tell me your name.
Justin Streitler.
Mr. Streichler, you're here in 2021 CL 2536AO on a charge of possession of a controlled substance. I did review the charging affidavit. In this case, I did find probable cause for your arrest. You're also on probation out of, I believe,
In Volusia County, Your Honor.
Volusia County. And you were arrested for a violation, on-view violation of your probation. They set your bond at $0. When I'm appointed public defender to represent you in your cases while you're here in our custody. And we'll get you on to your next, oh, sorry, we gotta stay your bond. Oh, we gotta stay with your bond. Sorry, oh, I did make a see, getting slow here. I'm gonna say your bond amount of $1,000. That's the 2021 CF 2536AO. Condition of your bond, no, may not possess any drugs or alcohol without a valid prescription. As to your VOP case, your bond $0. We're gonna get you on to Volusia County as soon as we can.
That's what, I'm going to be sent to Volusia County?
No, isn't that, it's out of Sarasota.
Sarasota? I'm sorry. I thought it said Daytona.
Because I live in Deltona and.
Oh, okay.
It started in
Sorry,
Sarasota.
Sarasota County. I'm sorry.
I got.
We get you other direction, West Coast.
I got transferred,
Correct.
I got transferred to Volusia, but I still have to go to Sarasota?
No, you gotta go to Sarasota County. Sorry, we'll get you back to Sarasota County.
Is there any, y'all have to transfer me? Or
Well, at some point between, like next week, between myself or my counterpart, Judge Gibson, we're probably, and the jail, we're gonna reach out to Sarasota County and the judges over there and see if they have any release conditions that they're willing to amend your case to. Otherwise, they'll get you on a bus to Sarasota as soon as we can.
Do we know when that is? I'm just curious. I need.
I don't know.
When you satisfy Orange County's case first, then they'll work on Sarasota.
Yeah.
You have
so-
to satisfy our charges first.
I understand that. I was just curious.
I don't know when, so I can't give you a date, time, place, I don't know.
They're the ones who come pick me up?
Yep, they'll come and pick you up.
Okay, thank you.
All right.
Good morning.
Tell me your name, sir.
Jason Strother.
Mr. Strother?
Yes, sir.
All right, Mr. Strother, you're here in 2021 CF 2534AO on quite a few charges. 2 counts of battery on a law enforcement officer, 1 count resisting officer with violence, possession of drug paraphernalia, providing false identification to a law enforcement officer, and attempted destruction of evidence.
The story is actually.
Don't talk about the facts.
Oh, no, I'm not talking about the facts. I'm just saying, like, it's just a big misunderstanding. So.
That's fine, but.
I was just homeless and trying to find some place.
I will tell you this.
That was
I
it.
was a prosecutor for quite a while. There's nothing a defendant has ever told a judge that was ever helpful to them without talking to their attorney first.
Oh, no, I'm not gonna get into
I
the
promise
facts,
you. You
but
could
it's just a big
say,
understanding.
I didn't do it. I wasn't there. Those are like great information that you can give to like prosecutor. Because then you can't claim a defense later on that, oh, they made a mistake. You say I wasn't there. But then here you are there on the video. So there's nothing, like I said, nothing, really. Very little the defendants ever said to a judge while sitting as a prosecutor to ever help them, except when they were talking to them. They got their advice from a lawyer first, all right?
No lawyer has talked to me yet.
All right. All right.
It was a big misunderstanding,
okay.
I promise you.
We're gonna stay your bond in count 1 amount of $2,500, count 3 at count 2, 150, count 3 at 150, count 4, 100, count 5, 100, count 6, 100. Condition of your bond, do not possess any drugs or alcohol without valid prescription. Want to appoint a public defender to represent you in this case? All right,
Yes, sir.
Your Honor, could you tell me the bond on count 1?
it's $2,500, I stated. All right, have a great day, sir.
Yeah, 'cause I didn't touch anybody.
Okay.
I didn't have any drugs or anything.
not losing my mind up here. All right, tell me your name, sir.
Shelton Tarver.
Mr. Tarver?
Yes, sir.
All right, Mr. Tarver, you're here in 2019 CF 3843AO for a failure to appear warrant. The judge signing your warrant set your bond at $0 in this case. Your bond remained at $0. We're going to appoint a public defender to represent you in this matter. Have a great day, sir.
I got a private attorney on
You got a private attorney? I'm sorry. Oh, who's your private attorney?
Robert Mandel.
All right, call Mr. Mandel and tell him what happened, where you are, so he can work on getting you in front of an appropriate judge for a bond hearing.
Yes, sir.
All right, have a great day.
Ron Taylor, you refuse court.
All right, this is Mr. Taylor in 2021 CF 2510AO. I'm going to appoint a public defender to represent him
We'll waive, Your Honor.
and state what he asking me to do to these, one punishable by life offense and the other one a life offense.
Your Honor, the state asks that you hold him no bond.
All right, Ms. George, you making any arguments on behalf of your client?
No, Your Honor, we reserve the right to have an argument hearing.
All right, based on that, the court is going to hold him at no bond as 2021 CF 2512AO. I'm going to make addition to his bond that he not possess any weapons or firearms. The weapons or firearms he has need to be turned over to law enforcement within 24 hours of his release. Had no contact with any victims or witnesses. No contact with any co-defendant, including a possible Michael Smith. Michael Martell Smith is on the warrant. Yeah, we don't know who he is. I would say co-defendants. They say co-defendants. Yep. And he not returned to the scene of the location. All right. Tell me your name, sir. Well, cover your face. Now you can tell me your name. Go ahead.
Eddie Laverne Thomas Jr.
All right, Mr. Thomas, you are here in 2021 CF 782AO for a charge of fleeing, attempt to elude law enforcement, and driving on license suspended. The judge signing your warrant has already found probable cause for your arrest. I'm going to set your bond in count one in amount of $5,000. Count two will remain at $5,000. Condition of your bond, you may not operate a motor vehicle without a valid driver's license. I'm going to appoint a public defender to represent you in your case. Have a great day, sir. All right, tell me your name, sir.
Christopher Anthony Torres, sir.
All right, Mr. Torres, you're here in 2021 CF 2547AO on charges of possession of methamphetamine and possession of drug paraphernalia. And you're also here in 2021 CF 2545AO on charge of burglary of an unoccupied structure and petty theft. The court did review the charging affidavit in both cases, did find probable cause for your arrest in both cases. I'm going to stay your bond in 2021 CF 2547 in the amount of $1,000 and $100. Condition that bond not possessing any drugs or alcohol without valid prescription. You're in 2021 CF 2545, we're going to stay your bond amount of $2,500 and $100. Condition of that is no return to the scene of the location, no contact with any victims or witnesses. No, it was 2000. Oh, I'm sorry. I forgot. Yep, because of bond correction thing. Sorry, staying your bond at $3,500. I apologize. And then your count two is $100. Yep. And you were out on bond in 2021 CT 459, 2021 CT 458, 2021 CF 660, and 2021 MM 393. Of course, going to revoke all those bonds, set new bonds at $0. I'm going to appoint a public defender to represent you in all your cases. Have a great day, sir.
So I have no bond, basically.
As to the old cases, no. As to the new cases, yes.
Sir, I mean,
All right, wait. Talk to Ms. George if you got any questions. Everything you tell me is being recorded.
I don't understand that, sir.
Yeah, so basically this is how the law works. Everybody in the state of Florida is arrested on a charge is entitled to bond unless you're charged with a life felony or punishable life offense, or offense punishable by death. So I had to give you a bond as to the new cases you're arrested on. I don't have to keep you out on bond on the cases that you're out on. That's what the law also says. So that's what I did.
Sir,
Have a great day.
Don't talk about.
Have a great day, sir.
No, I'm not talking about.
Cover your nose and have a great day.
Be nice.
Good afternoon, sir. Tell me your name.
Wilgen Sherry.
Is Sherry your last name or your first name?
Last name.
All right, Mr. Sherry, you got more. You're here in 2021 CF 2537AO. The court's going to, I'm sorry, you sort of charged of possession of methamphetamine. The court did review the charging affidavit. I did find probable cause for your arrest. I'm going to state your bond amount of $1,000. Condition of your bond is you're not possessing any drugs, alcohol, without a valid prescription. Was he drug tested in this other PCR?
Yes, Your Honor. This is the defendant that you modified his pretrial release and added drug testing to it. It's the same defendant.
Ah, okay. All right. I don't know what I'm going to do, what I should do.
Your Honor, we would just ask that you, if you are going to revoke the bond, that you set a new bond as opposed to holding him at no bond. It is a possession charge, but it's a nonviolent offense.
Yeah, I'm more concerned that he was, I remember now that Mr. Davis reminded me, we were here on a separate charge, completely different charge. He was out on bond. Commits another new law offense, which was a trespass. We resolved the trespass. The only thing I didn't take any action on this case except modifying his conditions to add drug testing. Now we're back here about a month later for another charge. So,
Your Honor, but
how can I help him not see me anymore?
Your Honor, I would just say that he may have a drug issue.
Yep, and I give my speech. Don't I give the same spiel all the time?
Yes, Your Honor.
If you have a drug issue that you think you want to need help with, there are people here at the jail, the people downtown at the courthouse, other places in the community that can help you overcome that issue. But you have to want to do it. I can't make you do that. You got to want to see Judge Lattimore down the other end of the hall for drug court. You got to want to go through the program. You're going to have to want to overcome. It's an addiction. It's a disease that you got to fight. All right. All right, I dealt with the 2021 CF 2537 case. As to the case he's out on pretrial release in 2021 CF 1191AO, I am going to revoke the pretrial release. I am going to give him a bond. When it says bond, in that case, an amount of $4,000. Condition of the bond, men not possessing any drugs or alcohol without valid prescription. We'll appoint a public defender to represent him in all his cases. All right. Tell me your name, ma'am.
Quantisha Williams.
All right, Ms. Williams, you're here in 2021 CF 2540AO on charges of possession of cocaine with intent to sell and deliver and possession of cannabis. I'm going to set your bond in count one in the amount of $5,000. Count 2 in the amount of $100, condition with pretrial release supervision. That you had not possessed any drugs or alcohol without a valid prescription, you'd be subject to random drug and alcohol testing at your expense. Yes, with PTR.
Thank you.
All right, going to appoint a public defender to represent you.
A 30-day grace period.
I'll give her a 30-day grace period for any narcotics testing.
For any narcotics testing.
Oh, yes, no, thank you.
Mhm. Silly girl. All right, good afternoon, ma'am. Can you tell me your name?
Good afternoon, I'm Chanel Zenobia Williams.
All right, Ms. Williams, you're here in 2021 CF 1481AO on charge of grand theft. The court, sorry, the judge signed your warrant has already found probable cause for your arrest. They set your bond amount of $2,500, conditioning your bond that you not return to the scene of the incident and that you not have any contact with any victims or witnesses in that case.
Am I able to say anything?
Huh? State, what are you asking me to do as to this, her other felony case, 2020 CF 1280?
Your Honor, the state will request that you revoke it, given her history with prior batteries.
All right, Ms. Williams, you're in 2020 CF 1280. Oh, sorry, Ms. George, I'll point a public defender to represent you. Go ahead.
Your Honor, my client just went to court on that charge. She is set for trial in that case. So we would just ask that you not revoke it and set it at none. If you are inclined to revoke, that you increase the bond amount.
Based on her criminal history that I'm seeing, prior failure to appears, 6 felonies, 3 misdemeanors, and other arrests for batteries and thefts, the court's going to revoke your bond, set new bond at $0. And we'll get you on to your trial dates in your old case and to your new dates in your new felony case.
So I'm not able to talk?
Not as to the old case. All right, have a great day, ma'am.
So I have no bond?
Not as to the old case.
I'm fighting the charge, so I just left court yesterday, and if I would've took the plea to do the pretrial diversion, I didn't do it, because I know, when I seen the video, that it doesn't show anything, so.
That's between you and that's not what I'm dealing with today. Cover your face and your nose. That's not what I'm here to deal with today. You can talk to your attorney as to that, and then get you onto your trial dates, because we got trials going on left and right downtown, so.
Trial ain't gonna be until 3-4 months, everything's gonna be getting pushed back.
I doubt that. We have trials all the time now downtown, so you may want to call your attorney and talk to them about getting you a faster trial date. By the way, there you go. All right, tell me your name, sir.
Elton Jenkins Jr.
All right, Mr. Jenkins, you're here in 2007 CF 2552AO on a violation of probation. Hold on, wait a second. All right. The judge in that case set your bond at $0. Sir, you're a violent felony offender of special concern. You're not entitled to release until your case is resolved. I'm going to appoint a public defender to represent you in this case. Have a great day, sir.
Anything I could say, Judge Bain?
Probably nothing's going to help you, because the law says I can't release you, so, because of the charge you're on probation for.
But I've never been committed as a violent felony offender.
Well, you're on probation for manslaughter with a firearm.
Yes, sir.
Manslaughter is a enumerated offense in 948.06 that the entitled labels you as a violent felony offender of special concern.
So there's no bond or chance for...
Not until your case is resolved. All right. Have a great day, sir.
Okay.
All right, tell me your name, sir.
Samuel Majoran.
All right, is it Majoran? Mr. Majoran, you're here in 2018 CF 5355 AO for violation of probation. The judge signed your warrant, set your bond at $0. You are a violent felony offender of special concern. You're not entitled to release until your violation of probation is resolved. I want to appoint a public defender to represent you in that case. You're also here in 2020 MM 3888, which is a case out of Lake County for an out-of-county warrant. The judge in Lake County set your bond at $0. I want to appoint a public defender to represent you while you're in my custody on that case as well. Have a great day, sir. All right. Good afternoon, man. Can you tell me your name?
Portia J. Rugas.
Ms. Rugas, you're here in 2019 CF 15164BO on violation of probation. The judge signed your warrant, set your bond at $0. I'm going to appoint a public defender to represent you in this case. Have a great day, ma'am.
Sir, I have a question for you. I have, I got transferred already from Lake County over here. I've been over there for like 60 days, and they already sentenced me over there for 24 months community control.
Okay.
There's no other way that we could see as far as even running it concurrent
Well,
with
you're
that?
going to see Judge Lattimore very soon on a VOP arraignment, so that'll be happening in courtroom 3. So you can talk to her when you see her.
Okay, so I'll get a court date as far as for that?
Yep, you'll get a court date, and the public defender's office is appointed to represent you. So you'll get on to discuss that with your attorney.
Okay, thank you.
All right. Good afternoon, sir. Can you tell me your name?
Daryl Francis.
All right, Mr. Francis, you're here on a Osceola County warrant in 2021 CF 287 AO. The judge in that case set your bond at $8,000 as the count 1, $2,000 as the count 2. The condition of your bond: no contact with the victims or witnesses, no return to the scene of the location, no secondhand pawn transactions while you're out on release.
What? I don't have any holes in Osceola.
That's the Osceola case that you have on hold. It's $8,000 on count 1, $2,000 on count 2.
Okay, thank you so much.
$10,000 in total. Good afternoon, sir. Can you tell me your name?
Cameron Green.
Mr. Green, you're here on 2 out-of-county warrants. Forgot to write it down. I think it's Osceola as well. Oh, Manatee. From Manatee County. First one is 2021 CF 304 AO and 2021 MM 311 AO. In the felony case, your bond is $1,500 in count. And in the misdemeanor case, your bond is none. I'm going to appoint a public defender to represent you in those 2 cases. While you're here in my custody, we'll get you on to Manatee County as soon as we can. Have a great day, sir. All right, tell me your name, sir. Mr. Lopez Neff, you're here in 2020 CF 2108, a case out of Pinellas County for a violation of probation. The judge signed your violation of probation warrant, set your bond at $0. We're going to appoint a public defender to represent you in this case and get you on to Pinellas County as soon as we can.
Yes, sir.
Have a great day.
Thanks, sir.
All right. Marcelo. Yep. All right, Mr. Marcelo Mellon is here for an Osceola County case, 2020 CT 658 AO. We're going to appoint a public defender to represent him.
We'll waive.
All right, he has a bond at $9,999. We'll state the bond that amount, and he can bond out, or we'll send him down to Osceola. I had Quiones bonded, and now we have Thrasher. Tell me your name, sir.
Michael Thrasher.
All right, Mr. Thrasher, you're here in a Polk County case. The judge signing your warrant set your bond at $0. It kind of made a notation, just for the record, that for it to be set at initial appearances. The problem with that was that the first count that he's being charged with is robbery with a firearm. The second one is aggravated battery with a deadly weapon and domestic violence. False imprisonment, domestic violence. So I can do these two things, Mr. Asher. I'm comfortable setting bonds on counts 2 and 3 for you, but count 1 is a punishable life offense, and I'm not really comfortable setting a bond when I'm not the judge or the circuit handling that kind of case. So I can leave all your bonds at 0, or I can, set some of them.
Sorry, Your Honor, I don't understand.
They gave him a $1,000 cash bond on count 3.
Oh, yeah, sorry, $1,000 on count 3. So your bond on count 3 is $1,000. They gave you no bond as to count 2 and count 1. All right, so the charge in count 1 is, you can go to prison for life for that. I don't feel comfortable setting a bond when I'm not the judge and or circuit handling that case. So I don't have any direct connection, so I can't get on the phone or call, go around the hall and speak to the judge whose case this is. So I don't feel comfortable setting a bond at that amount, so I want to stay your bond at $0 as to count 1. I can set your bond at count 2 if you would like, or you can just wait to get to Polk County to handle everything at once.
Okay, I don't understand, Your Honor. So if I bond out for one, I cannot bond out for the other?
Correct.
So if I bond out for count 2, I get to walk out?
No, because you're still being held on count 1.
I'm not sure. I thought I was able to speak with the public defender.
Well, Ms. George is right there. Ms. George, you understand what I'm telling him? And see if you can say a different way to maybe help him out. Can I get a no contact order for him, though? This is a DV case. Can I get a no contact order for him?
Your Honor, we just ask that you set it at no bond for now.
All right. So I'll stay your bond in count 1 and 2 at $0. I'll keep your bond set at count 3 at the amount of $1,000. I make a condition of your bond, though, that you had no contact with the victim in this case, that you maintain a separate residence from the victim, that you not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'll give you a one-time return with law enforcement to retrieve any personal items if you are released. All right? And we'll get you on. I'll talk to Judge Jobson, who's the contact for Polk County, and hopefully we can get that taken care of soon. All right? Have a great day, sir. All right, sir, tell me your name.
Heriberto Torres Maldonado.
All right, Mr. Torres Maldonado, you're here for an Osceola County writ of bodily attachment. The judge set your purge at $1,000. So you can pay that amount of money, or we can get you onto your hearing for Osceola County as soon as we can.
I can try to pay the 1,000.
Say again?
I'll try to pay the 1,000.
All right, have a great day, sir. All right, tell me your name, ma'am.
Marquisia White.
All right, Ms. White, you're here in 2019 MM 2604. The judge signing your warrant out of Osceola County set your bond in the amount of $1,000. Condition your bond that you not return to the location of the incident.
I didn't know I had.
I'm appointed public defender to represent you, and we can get you on. See? Yep. The judge ROR so the warrant only came with one bond amount. I read the warrant. So she's released on the other count, as far as I know. And, well, okay. They only issued a warrant for one of the charges. All right, so there was some confusion. You were originally arrested on 2 charges. The judge only issued a warrant for one of the charges, was the trespass. They released you on your other charge, was the false information. So the bond is $1,000. Going to appoint a public defender to represent you, and you cannot return to the scene of the location where the incident happened while you're out on release. All right? All right, have a great day, ma'am. All right, does anybody have anything else for the better of the order? VA, yes, you telling me?
No, Your Honor.
Okay. All right, we are adjourned into the morning.